live.
Okay, we are meeting today because an election protest has been initiated. That happens when a candidate or a registered voter eligible to participate in the contested contest files a protest with the County Board of Elections where the alleged problem occurred. The County Board first engages in a preliminary consideration, and that is what our meeting is about, the election protest preliminary consideration. Peter,
Yeah.
You're welcome to have public comment for 3 minutes if you need to.
My public comment is I'm really interested in learning more about this.
So am I. Okay, so first of all, we got an email from Paul Cox, the General Counsel for North Carolina State Board of Elections, and we were advised that the state board is taking jurisdiction over protests challenging voters without driver's license, social security numbers on their registration record. UOCAVA voters who never resided in North Carolina, and UOCAVA voters who did not provide photo ID, and that no county board should consider those protests further. So 2 of the protests that were issued were regarding voters who did not have driver's license or social security numbers on their registration record. And we did look, and many of those dated back to before those were required on the voter registration. But that's nothing we have to, as a county board, worry about at this point. It goes to the state. The other thing was about UOCAVA voters who never resided in North Carolina. We did have one case that was related to that, but it's not under our jurisdiction according to the General Counsel. So what we are considering is the protests filed regarding deaths. And so what we went ahead and did, there were 6 ballots of people who passed away up to and on election day, who were identified from the November DHH list. The county board did not receive that list, if I'm correct, until after the date of the election. So that information wasn't available to our county board at that time. So what we are here to discuss is, can we proceed with recounting and retracting those votes, or do we not allow the hearing that would be required to go forward? So I'll open the floor to discussion.
So I think from my perspective, I've kind of looked at it, I suppose, from 2 angles. That we've got the state guidance and sort of custom that seems to be the case that's been long standing. And then after reading the brief that the protesters submitted and diving into some of the footnotes of the state guidance, I was bouncing around the various statutes and trying to find, are these people, just categorically barred? Do we have to declare them ineligible and retract the ballots? And so there is, I think, as simple as it would be for them to fix, it seems to be there is some ambiguity where the statutes that are cited don't really, truly, fully address the issue of counting ballots that were cast by voters who were otherwise qualified at the time, and then they died in the interim. Because even the state's guidance is that it's supposed to be taken as of election day. We have one person who died on election day. So I guess my position there is that the person's qualified. But the other individuals in the case that was cited by the protester's attorney, the Bouvier case, kind of operates in a it's not this context, it's a different context, where the case just cites the statute that includes somebody being dead as a disqualifying factor. But that doesn't, none of it really addresses this particular situation from the way that I have looked at it. And so I don't, that may be, I guess that's a decision that we have to look at in terms of weighing that lack of distinct clarity with, it's not exactly an agency of rulemaking, like it may be for other places, but it is a memorandum of guidance from the state board.
A memorandum of guidance that we should disqualify. We should disenfranchise these voters.
So their guidance, from the way that I have taken it, is that the ballots should be retracted. Yes, that's. I forget what footnote it is, but that is my understanding of what their guidance is.
The only reason that I would question it is that we received the information after the election was held. And I'm not sure if there's, I don't think there's anything written to address that, but I'm not sure. Dawn, I don't know if you want to clarify anything about what you looked at or what you guys looked at.
What we look at is each week we will, in our scene system, we can go in through scenes and check removed voters for anybody who had cast a ballot. It would say this person's been removed. We would address that at that point. That was done weekly before board meetings. And on election day, I would have to check with Charlene. If she checked that prior to canvass, well, these have not been removed from our system. So we had not received anything as far as death certificates or a near relative had notified us to remove these voters due to their passing. So that was, I'm not sure when they posted the DHHS list. That could have been prior to canvass. They were not on the October DHHS list. They were listed on the November. And when Charlene and Karen researched the provisionals and absentees, I'm not sure that the DHH list is on their checklist to check at this point. I know in the past it has not been.
Okay.
So that could be something that should be something now that the state's requiring us to check that list up until.
The other thing is that typically what happens when somebody is on that list that you do get, what do you guys do to verify?
That is from the Department of Health and Human Services. The state posts those on our intranet site each week. And once we receive that, we compare the name, the date of birth, other information that could precisely identify that voter. And if everything matches, then we remove that voter and attach the list from the Department of Health and Human Services.
And we get that list, not
We-
from,
That
not from the
the
Department of Human Service, Health and Human Services, but from the State Board of Elections.
state board receives it from the Department of Health and Human Services and posts it to the intranet. That's
So
correct.
in the past, we have followed protocol by receiving the list from the Board of Elections. We weren't supposed to ourselves somehow get it from the DHSS,
Well, we get that every week. We check it every
from the
week.
Board of Elections.
Right, from the state board. But in this case, we've never, what I'm saying is we do not, it has not been in our checklist to check after election day up until canvas.
Hmm.
We have not done that in the past.
Okay,
And evidently now it is required.
retroactively.
Mhm.
I think that is part of what I have a little trouble with, is that we're sort of going back and rewriting what we've already done after we've done it, and we were doing it as we were supposed to and have had done in the past. So I could understand more easily of this change moving forward, but to reverse engineer it raises a red flag with me.
Thoughts?
Well, if it was supposed to be done, and it wasn't. We're just dead before and after. That's my opinion. I mean, it might sound tough, but they're just as dead. In other words, I'd say that.
What do you?
If the state had given us a list of people, we would take them off. But the state did not provide that. And I'm of the opinion that this procedural glitch should not take precedent over what is ordinarily the practice of removing those persons from the list of voters. And so I would say remove.
Can I say one thing?
Certainly.
I'm not, I cannot say when they posted that list because like I said, I'm assuming it was after November 5th because one of the deceased is November 5th. We did not check that. So I don't know if they posted it before Canvas, where if that is the
Could have
rule
adjusted.
where we could have called it prior to that. Because we did not check it until after we received this protest. I just wanted to make that clear. Called and spoke with my district rep, and she said that this happened in another county back in 22, and they consider election day all of election day. Because I brought the point out that, I said we had one of the board members said, well, what if he or she passed at 7:31 after the polls close, and their idea is election day is all of election day, and that is so they have to be alive
Till the
basically
6th,
to the
or
6th, right?
whatever.
12:01
Yeah,
a.m.
yeah.
Until election day is over, not
Right,
until
till
the election is
day
over.
is over. That was the determination for that particular voter in 22.
Okay, so basically here are, and you can correct me if I'm wrong, we have two options. We can say that the Alamance County Board of Elections has administratively addressed, because what we would do is if we decided that we were going to go by the state's recommendation, which is that they that we don't count their vote, that we would reconvene canvass, that we've already identified those 6, and we would reconvene the canvass after the recount and retract those votes so that those votes did not count. Or we would agree that, that we need to go forward with the protest hearing. And at that point, there would be, then there could be the director, other staff members could testify under oath about what the records show, or the board could accept a notarized affidavit from a staff member explaining what the records show with respect to the voters. So those are our two choices at this time. So either we agree that they don't count this time. I guess we could ask for clarification in the future so that this kind of situation doesn't happen again, because obviously it's not just happening in our county, it's happened before. And give more clear directions to our county board of elections staff members, or we would agree that we need to meet again, and we would schedule a hearing within 5 business days of this meeting, and file a written decision within 3 business days of that hearing's conclusion. And of course, the business days don't count Thanksgiving or the Friday after. So those are, the way I see it, our two choices. So, I'm not sure. I'm not really. I've heard both of you. I see where you're both saying you think that they should not count. I'm not sure about the other two.
I guess my discomfort is that there is really not a clear precedent over it. But at the same time, I don't know where we get that's going to end up in some court ultimately. I will just say I don't feel comfortable striking people's votes when the law is not clear, and that's my feeling.
No.
So you're saying the law is not clear on striking deceased people's name from the rolls at all, or
No, not at all. There's certainly the list maintenance statute.
Yes.
I think the lack of clarity for me comes up when you have people who, at the time they pass the vote, they are eligible voters.
Yes.
But then they become deceased before election day.
Right.
And so they obviously couldn't have voted then. But it's not clear from my reading of the statutes that their vote suddenly doesn't count because they were dead on election day. I mean, that's the state's guidance is that is what it is, that it doesn't count. And I don't really think it's settled, but
So you're saying you feel like we are not the group that should be deciding this?
I feel like it's something that needs to be, frankly, settled by the courts or the legislature. I mean, better the legislature, because it's really, in my view, an easy fix. But I think they've just sort of, I don't know if they've gone along with, well, this is kind of how we've always done it.
So you're saying in list maintenance they're removed because they're removed after they die, but they have not cast the vote. They've already been
Right.
removed after their death.
Right.
But there is not a clear statute saying what happens if you cast a vote and then died.
Right. That is my understanding from having looked at it, including the brief that was submitted by the council for the protester.
But if election day is counted as the election day, maybe I'm missing the vote. But if election day is actually the election day and the pre-votes or the early voting only counts for election day, and they die before or on election day is thrown out, then it's out. That's the way I'm looking at it. It's just
He's saying he doesn't necessarily disagree.
I
It's just not-
don't fundamentally disagree with that perspective. I think it's just not directly addressed, really.
And so to take away a vote when there's not a law that tells you should take away the vote. It's
I
problematic.
think we would be relying on the state board's guidance and reading into a case that's not specifically directed at this is a different context. And I don't think the statutes themselves, even if they cite, even to some extent that the state board cites in their numbered memo, is really definitive. But at the same time, I don't know where they show up here and make their argument. That might change my mind. I don't know. But
My thought is that we function under the authority of the State Board of Elections. And the State Board of Elections has given us historically some guidance about how we should proceed. And that there was a piece of that in terms of timing that did not materialize in this situation. But even so, I think that we do operate under the authority of the State Board of Elections, and we should follow the guidance that they have given us. But along with following that guidance, I think that we also should communicate to them our dis-ease and our desire for them to follow up with more concrete and explicit directions about how we should handle a similar
For the what?
situation in the future.
For the legislature to do that?
Well,
Because,
to the board.
because the solution would come from the legislature,
Right.
not from
Right,
the state
Right,
board.
the decision will come from the legislature, but in our recommendation to the state board, we could also say that we hope that they would pursue this
Mhm.
clarity.
So that we don't find ourselves in the
Through the
same
legislation.
situation again. Yeah, but I was in the office when the phone call to the state board was made, and they advised. I heard you ask many of the same. Dawn asked me.
Issues, are they taking it out of our hands? But in this issue, they're leaving it with us as if we do have a choice.
That's a real question.
Because if they just took it away from us, that would clear my conscience. But the fact that we're still given the duty to make a decision is, to me, is
Yeah, the statement we
Problematic.
got from the general counsel was the county board must keep and consider the protests filed by these candidates concerning felon status, deaths, and lack of registration.
I think what the reasons that one is the registration is simply because of the law. Or again, I'm going to use this example. If you registered 20 years ago, it was not required for you to list your driver's license and date of birth. And so, but the first time you present to vote, you would have to provide a HAVA document with your name and current address on it. Now that what they're protesting is voters that have voter history that still currently do not have a driver's license or social security last 4 digits on their record, but have voted. And the law now requires that. And we still don't have those numbers on these voters.
so it sounds like the fact that it's not a law necessarily is why they're making us decide it, because if it was clear in the law, they would just take it from us and settle it.
It seems clear that the State Board of Elections is punting
Yeah.
on this
To us.
to us. And I don't know the reasons why, but
Because there's not a law.
well, because there's not a law, but that's why we're recommending to them that they follow up with the state legislature in order to get some greater clarity, some legal guidance or some legal directive about how this situation should be handled.
So
And that's really a line. they need to write into the law.
What I'm
It's pretty much a sentence.
So I'm also hearing a third possibility. And the third possibility was that if I'm hearing correctly, that we all agree that there's some ambiguity or lack of clarity about this. That should we choose to say that we are going to reconvene canvass after the recount and retract those votes, that we do at the same time write a letter to the state board with recommendations that they provide clarity in the future for situations like this.
And I also would make it even more directive that, and it appears to us that you need to work through the state legislature in order to get that clarity.
And then I think that's a must because they've made their position pretty clear.
The state
I
board,
think, yeah.
they're not going to decide for us.
Well, and I think they have made through their
Recommendations.
guidance and their sort of going along with how things have been, if you will, that they're gonna say that's what it is and that's what we're going with. And
If based on the recommendation that was given to the director of Alamance County Board of Elections, they're recommending that, the way I heard it, they're recommending that we do retract those votes.
But I'm with him in about, I'm a 50-50. I don't want, this don't make, I'd put it back to them and say, you're the boss.
Yeah.
I mean,
Why make us make a decision
Yeah.
that is questionably
it
legal?
could go either way. It's
Yeah,
still.
because then we're responsible
Yeah,
for making law, basically.
I mean,
We're already quasi judicial. We don't want to be quasi legislative.
So let me just ask this. So if we schedule a hearing, who is going to come testify either way?
And this
Because,
is due to a protest, right?
yes, this is due to a protest asking us
Not,
from one of the candidates,
Mhm.
asking that we look at these votes and make a decision about whether we count or don't count them. And so, under the guidance here is that the county board engages in preliminary consideration, which we're doing right now, and decides whether the protest from that candidate demonstrates probable cause and whether it substantially complies with the following requirements. If it does, if we decide today that there is enough evidence that there's some kind of, I guess, lack of clarity in how we should address this, then it goes to a protest hearing and we'll assess evidence in the form of witness testimony, affidavits, documents, any other evidence presented. What could be presented that I've heard would be Dawn could go back to staff members and look to see when the information came from the state about those people who passed away.
But even if that's true, from what we've talked about here, that's not actually the issue. The issue is, are we the governing body that makes this decision?
So
this is a preliminary hearing, right? We're not
Yeah.
deciding it unless we decide that it's not,
Right.
that it doesn't have standing.
but the county board has to determine whether at that point during that protest hearing, the hearing, not this one, the county board will determine whether there's substantial evidence that voting irregularities occurred and whether the irregularities were outcome determinant. So once it goes to the hearing, then we have to note if voting irregularities occurred. Would these fall into the area of voting irregularities? And would it be enough to be outcome determinative in this race?
But we don't decide that in our county because it's a statewide race,
The
right?
county board will determine.
No, but I mean, we can't decide if it's outcome determinative because it's 100 counties have to.
And I think there is some, I did not read that statute because I didn't, I kind of got stuck in what I've been talking about. But I think there is some clarity as to how to consider things if it's a multi-county dispute.
Okay.
I just asked Charlene to find the prior guidance from the state board that we received for removing deceased voters, so we can
Look at that.
look at that.
It also says here, just to follow up on that, about the county board will determine whether there's substantial evidence that voting irregularities occurred. I don't know that this qualifies as a voting irregularity. And whether irregularities were outcome determinative. An interested party may appeal the county board's determination to the state board. So
The interested party that did first.
the interested party is that
Is
Who's
the
is still
protest.
still the protest.
The
And
protester who is a judge. Right?
The protester
candidate for
is the
this.
candidate.
so I guess we can keep discussing, and she's going to bring us that information. Can,
But we'll
can-
be, if my understanding is that our main problem with it, with this situation is not going to be resolved we're not saying necessarily that we think that there's been a voting irregularity. We're saying, and so that with a possible likelihood of that go to a hearing where we determine that, we're saying that there's good reason to think that we don't have the standing to make this decision,
But they passed it off to us.
but they pass it off to us. So, I mean, I'm just coming up with ideas, but I mean, I'm very tempted to at least abstain from voting on this because, well, I'm very glad for your insight, but I also, these are just things you said in a board meeting. And it's possible that, and it might be worth having it be looked at even by more than just us in this conversation.
So, I mean, my hope also, obviously, they requested to hear, they would actually hear their counsel. Like I'm saying, for them to show up and maybe they can set out line
Make their-
items that, I wouldn't write a brief and state my life on the work that I did looking at it last night and this morning and say, that's how it is.
Right.
And so maybe, they have their attorney show up and they can persuade me that I'm wrong or stupid or
So you're,
one of the others.
Okay, Dawn,
so do you mind if I ask you what your ideal outcome of this particular meeting would be?
I mean, from my view,
I mean, for our decision, like, should we go to the hearing is basically my question.
I feel like it should go. That's my position.
That's the general statute.
And this is their
Well, that's
list
still not the-
maintenance.
Yeah, that's not the guidance that's coming in numbered memo.
Yeah.
That's what I told
And I
Charlene.
think I
we
looked
needed.
at that, it's like 2022 guidance.
Oh, so you
2022
would,
out of 5,
okay.
I think. And that may be where I was thinking of the footnote that I'd seen.
And there,
But looking at that, it probably be helpful to everybody to look at it.
And the hearing that you're talking about is the hearing that the Alamance County Board of Elections would have.
yeah, this is a preliminary hearing, so it would be the
Actual protest hearing.
protest hearing, in which they would come and make their case.
Mhm.
I don't know, is it possible that there would be other developments? I mean, other counties are considering this too. Surely we're not the only ones that are wondering why we're deciding this. And there might be, in the meantime, I don't know, that's just how that may be too hopeful.
It probably is, but I mean, it's possible that they resolve this through some emergency decision above
Well,
everybody.
yeah.
Well above everybody here.
let me just ask, Jack, So when we started this meeting, I said there were two ideas, basically. One would be that we would have this discussion and we would decide that we go to a hearing. The second would be that since we've already identified the six, that we will reconvene the canvas after the recount and track those votes. What happens? I guess we have how many days? We have 5 business days after this meeting. And then we have to file a written decision within
Friday.
3 business days.
Friday, Monday, Tuesday, Wednesday, Monday.
Thanksgiving. Yeah, it goes.
After Thanksgiving.
That goes to after Thanksgiving. And that means that we don't have official vote until after Thanksgiving. Is that correct?
Well, we've already done the
If
canvas.
we
It would
fix
be,
it to a
Yeah.
hearing,
it would be redoing what we've already done
Yeah,
at that point.
But-
which is what we'd have to do now too.
You're already kind of outside of the bounds of our canvas.
Mhm.
So it's within the bounds of state canvas.
and that state canvas is what?
I can find out.
Okay.
So if we were to vote that these ballots aren't accepted, that we take them out, would and I'm trying not to get into the mind of the candidate, but would the person then come back to us with a protest of the decision, or would they follow up with the state?
The state.
Yeah,
but the
it does.
state's telling us what to do.
Yeah, what we could do at the end of this meeting today is we could basically agree that we're going to basically revoke those votes.
They can read it.
And
I'm
that
just
would-
saying,
they-
I've
their
given
protest
to-
For
to
this
people.
county, and
Okay.
though it could go on with other counties.
Yeah, my feeling is that we should not accept those ballots, and that if it's called for, give the explanation that we're following state guidelines in doing this. And it seems to me that would give the direction to the protester that they need to follow up with the state and
What would they follow up with on the state?
the state board of elections.
Yeah, but what would they follow up about?
They would follow up with the state board of elections guidance to us to not accept those votes.
But they're happy if we
Yeah.
accept them. They're just, that's what they want.
That's why they're challenging them.
Yeah, they want us to not accept those votes,
So if we don't, then
which that shouldn't enter into it at all. We have to make the decision on what we think is the proper course of action, not what benefits one side or another.
So
Yes, Dawn?
Well, here's the numbered memo, 2022-05, that it asks a specific question: what if a voter dies after voting absentee, by mail, or early voting, but before election day? And it's basically the guidance.
before or on election day.
It just says
It just says
before
before.
election day. It's number
Keep an
6.
address.
It's number 6 if y'all would like to read.
And so, yeah, obviously I'll pass it around, but basically they're saying, yeah, we're supposed to do this list maintenance. Of course we are. That's what we do. We don't know what they did with it this time or not. Follow the procedure about how to approve or disapprove ballot applications and challenges. And then after that decision's been made or after that procedure's been followed, then they get it struck for listing.
My question though,
But like I said, I'll
have you
pass it
received
around.
any additional information from the state specific to this? Because this makes it seem like we should count the one on election day. Because doesn't that say before election day?
That question did say before election day.
And so we could disallow the 5 that we're doing. All in favor?
So taking the 5 off and leaving the 1.
Based on that,
Yes, ma'am.
I agree.
Nah.
I still think we could, as a board, write a letter
Oh, yeah.
with our concerns, and I think we should.
Oh, absolutely.
Yes, ma'am.
Absolutely.
Okay, so I'll take that as a motion, and all of us agree to do that. We need to do that.
So you want to say-
I,
Like I said, I mean, I think this is probably the right outcome, but I just don't. I didn't feel comfortable
And we can
with
cite
where it-
that.
where it
No, I-
was right now.
and I understand that, and I appreciate that. I mean, I think there's a lot of merit in that. Except I'm just feeling that our hands are tied.
Okay, so do I hear a motion to adjourn this preliminary preliminary consideration for the election
does
process?
that mean that we have the hearing for the 1?
I guess you have to.
Why would we have to have one?
Because
We're rejecting.
we're rejecting one of them.
Saying that we disagree with your protest of that vote.
That is correct.
Well, we just approved it, so I guess we have to have a hearing.
All right.
If they decide they still want one, everyone. but-
Well, that'll give us, that will give us, then we can, if nobody comes, we write our written decision about why we did it that way. I mean, base it on
And on
that.
that one right
Yeah,
there.
base it on that if we don't have anything in addition. Okay, and if you locate
I
something
gotta go.
in writing, if you locate
Thank you.
something in writing, that changes that,
Noah, you leaving?
we
I
can,
have to.
Oh, you coming?
then we can schedule a meeting right away,
You can write.
right? Correct? It says schedule a hearing if required within
Thanks for the ride.
5
Oh,
business
sure.
days of preliminary consideration.
I mean, I get, if it just says within, I mean, I
Yeah, it
guess
says
we
within.
could just call it whatever.
We could
theory.
have it on Monday, correct?
But is that when y'all would like to hold it Monday? Are you talking Monday
The Monday
After
before
Thanksgiving.
Thanksgiving.
after Thanksgiving? Or,
Cause you gotta do it 5 days.
It has to be
then
Or this
Wednesday-
coming
next Wednesday,
Monday.
4 days.
scheduled here.
You want to finish the
Within
recount?
2 business days, you must conduct preliminary within 2 business. Schedule a hearing required within 5 business days. It doesn't say it has to be 5
Right.
later. We could schedule it for this coming Monday.
when y'all are here?
Mhm.
Okay,
And
I
then
can let
do
the
a written
interested
decision.
parties know if they want to,
Mhm.
you know, pursue that.
Yep.
What
So-
time would y'all like to schedule it?
I'd like to do it in the morning if possible.
That's fine.
Is that fine? Okay, so Monday. And that's the,
Yeah, that will work for me. I'll be here anyway. That'll give us time to look and see if we, for sure, if we have anything else in writing.
I can contact the, so that would be the 25th, Monday, the 25th.
What time did you say? Let's get our meeting, let's get stuff started down there, right?
Mhm.
And then,
Y'all, 10,
10 or 11.
10 or
What
11,
works
which
for
one?
you?
10 would be better.
Okay.
the 25th, correct?
Yes.
That's it.
We adjourn. Everybody,
Yes, sir. Second.
all in favor?
All right.